Following the matters of C.E.P. Limited, this is the Northwest Regional Health Authority, NWRHA, CP2024-6.
Morning, everyone. Do we have everyone here? The applicant, do we have the representative for the applicant?
Good morning, Madam Chair. Yes, CEP, the applicant, is represented here by myself, Haricharan Harnayan, the CEO of C.E.P. Limited. Alongside me is Mr. Vince Ramlochan, an associate, as well as Ms. Kimberly Rodriguez, who is sitting, she's an associate and a certified project manager as well. She's sitting in to listening and take our own records of the discussions at this hearing this morning. And Madam Chair, that's it for C.E.P. Limited.
Sure. Mr. Harnayan, I don't think we're seeing you though. And we're not seeing your camera on. If you could possibly turn on your camera. In addition, I believe you mentioned Mr. Ramlochan is with you. I believe he's one of the witnesses. So in terms of having the both witnesses together, he would need to be at a separate location. Oh, I'm not hearing
My
you.
apologies, Madam Chair. I was not aware of that because we thought that we could sit in. So are you saying that he must remove himself from this session, go to in another room and return when you call on him?
Yes, as the witness, yes.
Okay, well, we were not aware of that. Okay, well, that's not a problem.
Yes, yes.
So which means that you, based on your statement, Madam Chair, he would not be able to sign in to this session separately outside of this room, correct?
No,
And
no.
he must not be aware of the discussions that are going on right now in this particular session.
Yes.
Okay.
Yes.
Okay. All right. Sorry, my apologies. We were not aware of that, so we shall correct that immediately. Vince is leaving the room. He'll go and reside somewhere else. And when you are ready for him, does that mean then I will have to remove myself and then he will come in at that stage?
Well, no, you are the company's representative, so I'm not sure who is going to give their witness evidence first, but there's no issue with you remaining in the room whilst he's giving his, but he wouldn't be able to remain in the room whilst you are giving your evidence.
Okay, understood. Appreciated. Yes. So we'll comply accordingly, Madam Chair. My apologies once again.
So that's not a problem at all. Just to confirm, in terms of the representative for the respondent, do we have everyone here?
Yes, ma'am. One rundown for the NWRHA.
Okay, great. So thanks for giving us that information for our records in terms of the representatives for either parties. And we already, I believe, started with regards to some of the ground rules in terms of, the usual, you unmute your mic when you're speaking. When another party is speaking, you will mute your mic. If you would like to interject, you can just use the raise your hand button. We are monitoring the feed, so we will acknowledge and you will be able to raise any objection or the other. In terms of we are already discussed with regards to the evidence and with regards to the witness being in the room. We also ask that you don't have any unauthorized recording of the proceedings. You would be aware, I don't know if you are, that these proceedings are public proceedings, so they are already live on YouTube. So there's really no need for any further sort of recording. And in addition, if there's any sort of connection that's lost on your end during the period, if you would essentially just contact the office very quickly so we can address any sort of technical issues that may be happening on your side, and treat with the hearing accordingly so that you get back connectivity. Is that understood? Did anyone had any questions just with regards to those basic ground rules before we begin?
No, Madam Chair, we are okay at the applicant side.
Okay on this side.
Okay, great. All right, so in terms of before we start, we just wanted to look at any sort of preliminary matters that may be still lingering. There's one matter that we just needed to address, at least on our side for the Secretariat. In terms of the reply, I just wanted to ensure that the respondent, had you received a copy of the reply? Oh, sorry, not the respondent, the applicant.
Yes, Madam Chair, we did.
Okay. And Mr. Rondon, just from the Secretariat side, we would have received an application from you or your office asking for an additional time within which to file the reply.
Mm-hmm.
Yeah, so that would have come in on our side at the request at 12:02, and you would have filed the reply at 1:28. So we just want to confirm.
Yes, ma'am. So that's we were just getting things tight. We were running very close to the timeline. Just from a lessons learned standpoint, in converting the document from the OPR for it to be fillable, there was formatting issues. So from a lessons learned standpoint, if the form could be available either in a fillable PDF or even Word for us to document, it'll be good for the future, not for the future, but it'll be good for other participants.
Okay, certainly we would take a note of that. With regards to the technical challenge you would have experienced in relation to it. Mr. Rondon, is it possible that you can perhaps maybe get closer to your mic? You're coming across a bit muffled on the feed.
Let me see. It's better now?
Is it better? One moment. Well, proceed, and if we have any challenge, we'll let you know.
Okay, no problem.
Okay, and Mr. Harry Narayan, you already acknowledged that you would have received a copy of the reply, and I believe Mr. Rondon, from the reply, you indicated that you wouldn't have any witnesses.
No, ma'am, we have no witnesses. Yeah.
Okay, sure. All right, so with regards to the reply, unless there's any other issue, what we would do is that we would formally grant the request to extend the time for you to file that reply, which was filed with us at the 1:28 at 1:28.
Thank you.
And is there any other preliminary matter that either party wanted to raise before we move into the meat of the hearing?
From our end, the response by way of the skeletal submission, we were able, first, you might appreciate that this is very new in our context. So from a process standpoint, we know within a couple of days of the notice of the hearing, we should have submitted that skeletal review. If permitted, we can do same from a processing standpoint. It doesn't change anything from the reply, but just to ensure that we have all the documentation as required by the OPR, if permitted.
Sure. Well, at the end of the hearing, there will be an opportunity for the parties to give their closing arguments. So that can certainly fill the place of filing any sort of skeletal arguments. Yes, and I do believe the OPR would have already given some directions in terms of filing any written arguments by the 3rd of May, I believe. Would you have received that?
No, ma'am.
So yes, Madam Chair, we would have received that and we would have communicated to the OPR that we thought maybe there was an error because we thought that would have actually need to be submitted before this hearing on the 1st, but the OPR did communicate to us saying that no, it is correct that the documents required by the 3rd will be still stand by the 3rd. So we are quite aware of that. There are certain requirements still that could be complied with by the 3rd of May. So yes, we are aware of that. We were communicated and we accepted that.
Okay, sure. So for Mr. Rondon, what we will do, in as much as you've indicated that you wouldn't have received that communication, we will check our records just to make sure. And if anything, if you could contact us, or we will contact you just to confirm. We may have to resend if it was sent already and it didn't get your attention. If not, we will send it. Yes, so that you can use that opportunity as well to put your closing arguments.
Excellent.
Okay, you're welcome. Anything else from you, Mr. Rondon?
No, ma'am.
Okay,
Yes,
Mr.
decided.
Okay, great. Mr. Honorine, is there anything from your side before we begin?
Okay,
Well,
Madam Chair, just one formality.
Mhm.
Actually, my name is Haricharan Hanrai Maharaj, so my surname is actually Maharaj.
Oh,
But that's
okay.
okay. So
All
it's
right,
just
thanks
an
for that
exception.
correction.
It's a dual name. So, but in terms of surname, it's really Maharaj.
Okay,
That's
sure.
okay.
All right.
I
Thanks for
didn't
the
want to correct
correction.
you earlier, but I thought I'd do so now. No, but to answer your question, no, we are okay moving forward.
Okay, thank you, Mr. Maharaj. We'll do that. Okay, great. So in terms of no preliminary issues arising, what we would do now is, I'm just presuming that parties would have looked at our hearing rules that's available on the OPR's website and with regards to the conduct of the hearing. So that also guides as to what will take place at today's hearing. So at this juncture, what we will have is that the applicant, having raised an application for a challenge, will be given the opportunity to open his case by making submissions, a general opening statement with regards to summarizing what your case is about, what your challenge is about, etc., before you call your witnesses. I would give you perhaps maybe about 5 minutes to make your opening statement, and then we can look at calling your witnesses.
All right, so to please accept my apologies again, Madam Chair. So you are basically saying that we have 5 minutes to present our case, which is basically
No, not 5 minutes to present your case, 5 minutes to give an opening statement, and then you can move forward into calling your witnesses. So an opening statement as to what your case is about, what the challenge is that you have raised. If you need more time, if 5 minutes is too short, is that your suggestion?
Okay, well, Madam Chair, I'm a bit confused and please forgive me. This is the first time
Sure.
I'm sitting on one of these hearings, but I'm certainly I would assure you it would not be my last. So we would have sent, and please direct me accordingly, we would have sent our skeletal case submission, which to me, in my view and my interpretation, basically is the submission of our case. The witness statement is in support of that case, and the witness statements will be presented thereafter. Am I correct in interpretation?
Well, from what I understand, you would like to, rather than orally giving a presentation as to summarizing your case, you'd like to rely on the skeletal submissions that you would have filed.
Yes and no, because I want to make sure that we are on the same page, as it were, in terms of the context of our submission. I have no issues if time permits and if the panel allows, under your direction, Madam Chair, if I could briefly review our case.
Yes,
Right. So if you say it's approved, I will just go through it quickly. I mean, it was filed with the OPR. It was served upon the respondent. So we all parties, the OPR, the applicant, the respondent, are quite aware of the contents of our case. And the case that we are putting forward today was documented in our case submission, which was, as I said, was submitted. But I prefer that with your permission, Madam Chair, and those of the other members of your panel, that I will just briefly just run through it, if you would so permit me to do.
yes. Go ahead. This would be your opening statement as to what your case
Okay,
is.
thanks. So the opening statement of the applicant is that this submission is prepared for the challenge proceedings between C.E.P Limited, the applicant, and Northwest Regional Health Authority as a respondent on the case CP2024-6. It intends to provide a concise outline of the grounds for the request for review, as well as other key points to be raised by ourselves, the applicant. In so saying, C.E.P Limited submitted an application to the OPR for review of the Northwest Regional Health Authority's decision to award stage 1 of the contract for the construction of the multipurpose facility at Port of Spain General Hospital. And that refers to the RFP tender number 2024-02. And this was the intention of the Northwest, if you don't mind me abbreviating to the Northwest for speed, to Prudicom Limited. The decision of this Northwest was issued despite C.E.P's Limited attaining a higher score in the evaluation process than that of Prudicom. C.E.P Limited is of the opinion that Northwest's decision utilized the criteria that were not described within the RFP document, and I repeat, the criteria used by the Northwest to award this contract to Prudicom was not as described within the RFP, as such not consistent with the RFP document. And this is at the time of tender. C.E.P Limited is seeking re-evaluation of the tenders by the Northwest, utilizing the criteria established within the RFP at the time of tender. I would like, Madam Chair and other members of the panel, to basically summarize some of the key issues. The proposal submissions prepared by C.E.P Limited was in response to the requirements outlined within the RFP, and this would include but not be limited to the following: the terms of reference, conditions of contract, and evaluation criteria. Point 2. Clause 28, award of contract of Part C, instructions to proponents of the contained in the RFP, states that the Northwest shall award the contract to the proponent offering the most advantageous proposal. In our opinion, the most advantageous proposal is the proposal of the proponent that meets the qualification criteria and whose proposal has been determined to be substantially responsive to the RFP. Based on the contents of the notification of decision to award issued by the Northwest has deemed that the proposal submitted by C.E.P both meets the qualification criteria and has been determined to be substantially responsive to the RFP. Further, Clause 22 of the RFP, evaluation of proposals of Part C, instructions to proponents of the request for proposal, describes the criteria to be used to determine the most advantageous proposal. It also states that no other evaluation criteria or methodologies shall be permitted. And I repeat, no other evaluation criteria or methodologies shall be permitted. Based on the contents of the notification of the decision award issued by the Northwest at the end of the evaluation process, C.E.P was determined to have a higher score than Prudicom Limited. Notwithstanding this, the Northwest named Prudicom Limited to be the successful proponent and advised that they would be awarded stage 1 services only. The basis of this decision was based on Prudicom Limited submitting a lower cost for stage 1 services. And Madam Chair, if I'm moving too fast, please let me know. All right, I'll move on to the next point. The first paragraph of item C, commercial proposals of clause 22. Evaluation proposals of part C, instructions to proponents of the request for proposal states, and I quote, following the technical evaluation, when the selection is based on quality and cost, the commercial proposals of all proponents whose proposals were considered responsive and met the minimum qualifying technical score shall be opened as under RFP without negotiations. As such, it is our understanding that the basis of selection is to be based on quality and cost. That is, a quality and cost-based selection criteria. Next point, the notification of decision to award issued by the Northwest advised that C.E.P. Limited attained the requirements for consideration of the award of contract. However, Proceedings limited cost for stage 1 was 1.126 million less than C.E.P.'s limited cost of stage 1, which was 2.940. Consequently, Proceedings Limited was the selected proponent for the provision of the consultancy services for the construction of a multipurpose facility at Port of Spain General Hospital. Stage 1 services only. And I repeat, Madam Chair and other members of the board or the panel, sorry, stage 1 services only. Just to reflect on it, this project involved 2 stages. However, clause 31 of the Public Procurement of this and Disposal of Public Property Act 2025 states that, and I quote, a procuring entity shall not split procurement requirements for a given quantity of goods, works, or services to avoid obligations under the Act. We say that to say this. There was nothing in the RFP that indicated that the Northwest was or had the intention to award the contract in stages. It was always assessed by us and advised no other way in the RFP that Northwest retained the rights to award the contract in either stage 1, stage 2, or both. There was nothing in the RFP that certified and provided that provision. I move on, Madam Chair and other members of the panel. Upon receipt of the notification of the decision to award issued by the Northwest, C.E.P. proceeded to raise our concerns with the decision of the Northwest. A debriefing meeting. Sorry. May I continue, Madam Chair?
This is you're summarizing the case that you will be the
Yes.
C.E.P.'s case.
Yes.
Okay.
So it is.
Yes.
Just for guidance, is it the opening statement or are we in the case itself now?
Well, this is just an opening statement. I believe was the invitation to summarize what the case is, and then, of course, naturally, would lead into the witnesses that that C.E.P. Limited has.
So, Madam Chair, do I take it I may continue?
Yes.
Okay, so I'll move on. I do have a lot again, maybe a minute and a half or so much. Anyway, upon receipt of the notification of the decision of award issued by the Northwest, C.E.P. proceeded to raise concerns with the decision of the Northwest. A debriefing meeting was held to discuss this matter. However, the Northwest has not indicated that the decision will be amended, rescinded. As such, C.E.P. Limited submitted an application for review of the decision to the OPR. The application was submitted prior to the expiration of the standstill period. May I conclude then, in my opening statement, the following summary of our position. 1. C.E.P. Limited would have carried out a review of the contents of the RFP document submitted by the Northwest. I would have prepared a submission response to the requirements stated therein in totality. And I say in totality because we responded to all the aspects of the RFP. We complied fully with the RFP, and the evaluation of our submission would have indicated that we were in full compliance. Based on the contents of the second point, based on the contents of the notification of the decision to award issued by the Northwest has deemed that the proposal submitted by C.E.P. both meets the qualification criteria and has been determined to be substantially responsive to the request for proposal. Third point, further and pursuant to the evaluation of the proposals by Northwest, at the end of the evaluation process, CP was determined to have scored a higher than Prudicon Limited. CP's submission was evaluated to be most advantageous to the Northwest. Additionally, the Northwest decision to award Stage 1 of the services to Prudicon Limited because Prudicon's Limited cost for Stage 1 is less than CP cost for Stage 1, again repeat, is contrary to Clause 31 of the Public Procurement and Disposal Act. Again, a procuring entity shall not split procurement requirements for a quantity of goods, works, or services to avoid obligation on the contract. I will close by saying, pursuant to the proceedings, CP Limited is seeking re-evaluation of the tenders by the Northwest, utilizing the criteria established within the RFP document issued by Northwest at the time of tender. Madam Chair and other members of the panel and respondents attending, that is the end of his submission. It summarizes our case or position with respect to this particular matter, and we await direction from the panel on our next input.
Okay, thank you, Mr. Maharaj. In terms of the conduct of the hearing and the rules that are again available on the website, after the applicant opens his case, the applicant is then invited to call his witnesses. I appreciate you are one of the witnesses, Mr. Maharaj. And once you have concluded with regards to your witnesses, it is at that point we will then invite the respondent to give his opening statement. And Mr. Rondon, you've advised that you don't have any witnesses to call. So what that would mean for you, Mr. Rondon, is that when when the applicant is given evidence, there are two witnesses, you will also be invited to cross-examine if you have any questions that you would want to pose to the two witnesses for C.E.P. You would be invited after they give their evidence. Is that would that process be clear to both sides?
So just to summarize my understanding of your statement, Madam Chair, well, I think I may have missed something, but the next step is what you said? Sorry?
For your witnesses, yes.
Okay.
So as
Next
the
step,
applicant,
at the conclusion of the presentation of the statement by the respective witness, you are saying that the respondent has the opportunity to
ask
perform
questions.
questions to the witness. Is
Yes.
it at the end or during the presentation of the statement?
No, after. So
On conclusion of the statement, I want to make that abundantly clear. So the respondent will have the opportunity to present questions or prefer questions to the witness at the end of the delivery of the witness statement, correct?
yes, yes.
Okay, excellent. Okay.
Yes. Okay. All right. So that is clear to you. Mr. Rondon, is it clear on your side with regards to your rule?
Yes, ma'am. Very clear.
Okay, great. Thank you. So at this juncture, Mr. Maharaj, if you would call your witnesses, in as much as you're still presenting your case as the applicant, would you be the first witness?
Yes, since I'm here, Madam Chair, I will proceed to be, as you know, and as the respondent knows, we have two witnesses, myself and Mr. Vince Ramlochan. So I'll present my statement immediate now, and then I'll be, available for cross-examination by the respondent.
Yes, and just
Okay.
for me to mention, with regards to the panel themselves may have one or two questions, clarification questions of the witnesses. So we may or may not. And this, of course, would follow after the respondent has asked the questions.
Okay, fully understand.
Yeah, so that's
Madam
just to
Chair.
let you know. Okay, great.
Okay,
So just one moment. Okay. All right, great. So before you begin, Mr. Maharaj, you would just affirm, and I know you would have filed the witness statement, so we would just read out and you would repeat the affirmation after. Let me go ahead.
I state your name.
Oh, yeah, unmute, unmute.
I missed that part, Madam Chair. Could you just just go back through that full statement you made?
Sure. With regards to you are now the witness, and in terms of giving your evidence, so we're just going to ask you to affirm so that you're giving your evidence. And before you begin, so we are going to read out, one of the officers will read out the affirmation and you just repeat it after the officer.
Noted.
Okay, good.
Repeat after me. I
Haricharan Harnayan Maharaj
solemnly and sincerely
solemnly and
sincerely
sincerely
and truly affirm
and truly affirm
that the evidence
that the evidence
I shall give
I shall give
to the hearing panel
to the hearing panel
in this case shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Okay, great. Thank you. And in terms of your, do you have your witness statement with you? Let me just
Yes, I
get
do.
that. Okay, yes. If you would just like to go ahead and give your evidence.
Okay, so proceed now.
Yes, yes, you may proceed.
Okay, so I, Haricharan Harnayan Maharaj, Chief Executive Officer of C.E.P Limited of 97 Trackridge Road, Woodbrook, state the following. It was brought to my attention that the Northwest Regional Health Authority, via notice in the newspaper published on the 29th of November 2023, had invited tenderers to submit a bid for the consultancy services for the construction of a multi-purpose facility at the Port of Spain General Hospital. I approved the purchase of the RFP documents via Northwest Regional Health Authority e-tender portal. The purchase was transacted on the 30th of November 2023. The request for proposals for consultancy services for the construction of a multi-purpose facility at the Port of Spain General Hospital, RFP reference tenders 2024-02 dated 27th November 2023 was received on the 30th of November 2023. A pre-submission meeting was held on the 4th of December 2023. Mr. Vince Ramlushan, an associate of C.E.P Limited, was in attendance. A second pre-submission meeting was hosted by the Northwest Regional Health Authority on 13 December 2023. Mr. Vince Ramlushan, associate at C.E.P, was in attendance. I presided over the preparation of the proposal submission in response to the request for proposals. Upon completion, I, as the duly authorized representative of C.E.P, signed the proposal submission. C.E.P submitted their proposal on the 5th of January 2024 in accordance with the requirements set forth in the RFP. On 27th of March 2024, I was in receipt of the notification of decision to award stage 1 of the contract for the construction of a multi-purpose facility at the Port of Spain General Hospital to Proceedings Limited, as issued by Northwest Regional Health Authority via email. The letter issued by Northwest was dated the 26th of March 2024. The evaluation results provided by the Northwest within the notification of decision to award show C.E.P received a total score of 81.5 Procurement Limited received a score of 77.8. As a duly authorized representative of CP, I requested a debriefing meeting in relation to the notification of decision to award by letter dated 27th of March 2024. I attended the debriefing meeting session, which was held on the 5th of April 2024. I received a copy of the minutes of the meeting from the Northwest via email on the 8th of April 2024. Subsequent to the debriefing session, I wrote to the Northwest on 9th of April 2024, requesting that they advise concerning the way forward on the matter. In absence of a response from the Northwest on the matter, I submitted an application to the Office of Procurement Regulation on the 11th of April 2024 for review of the Northwest decision to award stage 1 of the contract for the construction of the multi-purpose facility at the Sportswain General Hospital, the Prodicom. I, Haricharan Maharaj, Chief Executive Officer of CP Limited, believe that the facts stated in this statement are true. Dated 29th of April 2024.
Thank you, Mr. Maharaj. So we'll just tender and mark that witness statement as HHM1. And with regards to Mr. Rondon, I believe you would now be in a position to ask any questions of Mr. Mr. Maharaj, based on his witness statement.
So at this point in time, we just want to confirm that the points allocation that have been identified, that Mr. Maharaj accepts that the point allocation, so he understands the evaluation criteria that was used, and he understands that the results of the points that were...
Is that a question? Well, just a moment. Is that a question you're posing to him, or it was a statement you were making?
No,
to him. Okay.
To him,
okay, sure. Okay, sure. Pose it as a question then, so he would understand to respond.
Right. So with regards to the evaluation criteria that was established in the RFP and the results of the evaluation criteria, are you in full understanding and agreement to what has been communicated to you?
I would like to answer that question this way, Madam Chair and other members of the panel. There's nothing in the RFP that indicated how these points would have been accumulated. However, we looked at it and we accepted in essential conclusion the point of 81, whatever we evaluate upon. We would have accepted that. But I must say, in our defense, there's nothing in the RFP that indicated how these points would have been established and determined.
So we provided a breakdown for you as part of the notice and showed each evaluation criteria and the points attained by same.
Yeah, and my response to that is that whilst you would have done that post-tender, understand me clearly, in the RFP, the tabulation of those points were not declared to the proponents. We were not we were not informed of how these points would have been evaluated.
Right. So do you accept the results, or you have a challenge with the results?
I will defer that to a later action if I can, Madam Chair and other members of the panel. It depends. We would reserve the right to do that later on.
So
Unless you have questions now,
Mr. Rondon, you have more questions?
no, ma'am. The response to the first question would have led to the second question, but if this is being deferred, well, I'll defer the second question also.
Well, there would not be any, today is the hearing, so there's not another opportunity to give evidence
Well, and this is what I'm
for
saying.
both sides.
Okay, so I mean, this is kind of, we want to be straightforward. We want to get a solution to this. We had an evaluation criteria. We have results to it. This proponent is the top ranked proponent. And we just are asking if the proponent understood and agreed with the result, because we're here today because one of his main arguments is that he is the top ranked proponent and we made another decision. So are you satisfied with the results that you got? Are you satisfied with the explanation of the criteria and the breakdown and award of points that was given to you by way of the standstill notice?
Okay, so Mr. Rondon, okay, as I said, well, unfortunately, you made a statement that this is a simple matter you're trying to get resolved, but this is actually.
Look,
Well,
please,
one
no,
moment, one moment.
please.
Let's
Let me finish.
Sure, just one moment. Let's just have, I think, Mr. Rondon, if you phrase your questions in bite size, because I realize your question may be a bit long, and we want to make sure that Mr. Maharaj captures the question to give an answer for your question. So before we start, if you could just break down your questions, Mr. Rondon, into a simple statement, get an answer from Mr. Maharaj, and then you move on to your next question. Rather than making any sort of statements, ask him directly the question. I hope that will assist.
Okay, no problem. Mr. Raj, are you aware of the points attained from the evaluation criteria for C.E.P Limited?
You're on mute, Mr. Maharaj.
Mr. Rondon, you're coming a little muffled as well. Could you just repeat?
Are you aware of the points that C.E.P Limited attained as part of this RFP process?
Yes, we are aware. It was documented to us in your letter dated the 26th that we would have received on the 27th.
And do you agree with the score given to C.E.P?
Mr. Rondon, that is a difficult question to answer. To say we agree, because we don't know what was the basis used by the Northwest to come up with those points, because it was not documented in the RFP.
So are you aware that C.E.P is the top ranked proponent?
Sorry, what?
Are you aware that C.E.P is the top ranked proponent by way of points for this RFP?
Yes, we are aware that we are the top rank.
Okay. And if I can lead in, what is your understanding and definition of most advantageous tender?
Sorry, I didn't hear that.
What is your understanding of most advantageous tender?
Okay, so okay, so let me explain. Your RFP did indicate that you would have come into negotiations with the highest ranked person.
So I'm just asking, what is your understanding of most advantageous tender?
Okay, so my understanding of the most advantageous, Mr. Rondon, is that we were the highest placed proponent, so it would have been more advantageous to the Northwest to enter into negotiations with us for this particular project.
Okay.
Sorry, that is our understanding.
All right. No further questions.
Okay, thank you, Mr. Rondon. Let me just find out if the panel has any clarification questions, Mr. Maharaj. I just had two questions for you, Mr. Maharaj, just to understand. In looking at the RFP document, I noted there was a site visit that was done before. I just wanted to appreciate, would you have attended the site visit? And would any information have been shared with the proponents or the intended proponents at that point?
Sorry, is that question directed to me?
Yes, yes, directed
Okay,
to you.
yeah. Madam Chair, in my written statement, I've indicated there were actually 2 site visits. Site visit, well, they call it pre-submission meeting, but it's the same thing. There was a pre-submission meeting held on the 4th of December, and then there was a second one held on the 13th of December. Both of these meetings were attended by Mr. Vince Ramlocha and one of our associates here.
Okay, so you wouldn't have attended the site visit?
No, I did not know, but the information gathered at that pre-tender submission would have been sent to me for my review in preparation of the response to the RFP.
Okay, okay, sure. Just with regards to the RFP and the commercial proposal section, as it related to the lowest, the methodology for the lowest cost calculation. If I could just get your understanding of perhaps maybe what is your appreciation of that methodology? It was, I think it's page 25.
Of the RFP?
Yes, 25, page 25 of the RFP. This was
Okay,
yours.
so yeah, so if I may, with your approval, I'll just read it. It says the proposal with the lowest cost will be given a commercial proposal score of 20. Is that what you're talking about, or you're talking
Yes,
about?
yes, yes.
Yeah, of 20 on the other. That's the commercial side. Okay. And then other proposals given a score. Yes, I'm fully aware of that. It's a proportional based assessment system based on the financial/commercial submission. Yes, I understand that. Of how that is calculated and obtained.
Okay.
But it's important, Madam Chair, if I may, with your permission, read the second line that follows. It says, once the proposal proponent attains at least the minimum score on the commercial proposal, the proponent will be ranked.
Yes, and your understanding of that was, what do you mean, enjoying it to attention?
Well, I'm drawing it to attention because in okay, if you may, with your permission, if I may direct your attention to page 26, negotiation of contract. Says in the case of a quantity cost-based system, the notaries reserve the right to enter into negotiation and as an appropriate, negotiate with the top rank proponent to clarify, among other things, the scope of services and the deliverables of the assignment. The objective of the negotiation will be for the Northwest to achieve the best value for money. Should the negotiations with the top rank proponent fail, discussions will be formally terminated, and then the commercial proposal of the next rank proponent will be opened and evaluated. And I emphasize this. Should the negotiations with the top rank proponent fail, the discussions will be formally terminated. The commercial proposal of the next rank proponent will be opened and evaluated. I apologize for not including my document. So what this is saying in my interpretation, the respondent may disagree or offer his own comments. The top rank proposal ought to have been opened, and then after failure of the negotiations, then all others could be opened.
Okay, thank you, Mr. Maharaj. Just in terms of Mr. Rondon, based on the, sorry, yeah, yes, Mr. Maharaj, my colleague on the panel, we just wanted to, he also had a clarification question for you.
Mr. Maharaj, at the pre-submission meetings, the first meeting or the second meeting, was any information revealed to you by the Northwest Regional Health Authority regarding a scoring rubric relative to the scores, right, or the scoring methodology identified in the ITB document?
I would have to, if you allow me to, I'll have to pull up my notes for those two meetings before I could answer that question with some level of authority. Because as you could recall, that would have been a few months ago. So I would, if you would permit me to pull up those records before I can answer that question.
Well, we wouldn't be able to, are you referring to records that you would have filed with the OPR already? Is it an attachment that you would like me to
it's our
assist
own,
you?
no, Madam Chair, it's our own personal records that we would have taken at the time of the attendance of the two pre-submission meetings.
Okay, well, we wouldn't have, neither the parties would have had sight of that. So we would have a little challenge in terms of you pulling up these records to rely on. But perhaps if you can, if it is you're not aware, if you can't recall, then you could just let us know that you can't recall.
Yeah, but to support that as well, Madam Chair, the Northwest would have prepared minutes of those meetings, and if there was anything that your colleague would have been asking for, would have been in their minutes, the minutes of their meetings. The meetings were conducted by them as well. So maybe neither parties would have filed that. I'm not sure.
Understood. So, well, if you can't recall at present, again, it's sufficient to say you can't recall. Mr. Maharaj, you've gone out of frame now. If we could just get you back in frame. As mentioned, you wouldn't be able to, Mr. Maharaj, yes, you wouldn't be, as I said, you wouldn't be able to rely on notes that would not have been shared with the OPR or the respondent being aware of it. So again, if you cannot recall, it is sufficient to say you cannot recall what would have occurred. And we will just move on. If we have any other questions, we will just move on to the other question. Is that clear? Is that clear?
Oh, I understand that, Madam Chair.
Okay.
But well, Madam Chair, if you give me a little extra moment, I would say that in our defense as well, the respondent didn't file the minutes of the meeting that was conducted on those two occasions. That's all I have to say.
Okay, great. All right. So let me see. Is there another question? We'll move on to the other question. That for clarification.
Mr. Maharaj, the article or item 23 of the instructions to the bidders, right? And I just want to just reread the first line, right? It says, in the case of a QCBS, the NWRHA reserves the right to enter into discussions. And my question in that regard is, did the NWRHA exercise, right, that right in terms of the reservation right or not during the evaluation and award decision to award the contract? That right, that reservation right that is stated in line 1.
We were not invited to any negotiations during the evaluation process.
Sure. Oh, I had one other question. Just to be clear, would you have been, Mr. Maharaj, would C.E.P have received any notice of cancellation of any of this tender or any stage in the tender at any point in time?
No, Madam Chair.
Okay, thank you. Yeah. Okay, I think those are the questions for the for the panel based on the questions that we have asked from the panel's perspective. If there's anything else that arises, Mr. Rondon, that you would like to ask a question on of Mr. Maharaj, we would invite you to do so now based on the clarification questions asked by the panel. Nothing new that you yourself would not have raised.
So, from our end, with regards to clause, hello?
Yeah.
Yeah. So with regards to the clause 23, where the negotiation, the NWRHA reserves the right, I just didn't get the understanding from Mr. Maraj if
Ask him a question. Ask him. Don't give us a statement. Ask Mr. Maraj based on the questions asked of the panel. Could you ask Mr. Maraj if anything arose?
Mr. Maraj, with regards to clause 23, the negotiation on the NWRHA reserving the right, do you deem this clause to be a mandatory clause or a non-mandatory clause?
We interpret it to be a mandatory requirement.
Okay. That's it for me.
Okay, thank you. That is it for us, Mr. Maharaj, with regards to your testimony. Would you like to call your other witness? You'd like to invite him?
Yeah, okay, just give me 1 minute.
Sure.
Let me just bring him into the room. But Madam Chair, just to clarify and confirm that I would still be able to sit in the meeting but not say anything
Yeah.
during that. Okay, excellent.
Yes.
Good morning.
Good morning, Mr. Is it Filochan?
Ramlochan.
Ramlochan. Sorry about that, Mr.
Not a
Ramlochan.
problem.
Okay, yes, just to give you an understanding of how we would proceed. So you would have submitted a witness statement. So before you start giving your evidence, one of our officers at the OPR will give you an affirmation, which you repeat after the officer, and then you can go into your witness statement that would have been filed and of course already shared with the respondent. After you've given your evidence, the respondent has an opportunity to ask you questions based on your statement. And following which the panel ourselves, the members, we may also have clarification questions for you just so that we can get a clear understanding and a picture of your evidence. And that essentially is it. So we'll now move into the affirmation, and you'll just repeat after the officer.
Understood.
Repeat after me. I state your name.
I, Vince Ramlochan,
Do solemnly and sincerely
do solemnly and sincerely
and truly affirm
and truly affirm
that the evidence
that the evidence
I shall give
I shall give
to the hearing panel
to the hearing panel
in this case
in this case
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Okay, go ahead, Mr. Ramluchan.
All right, so I will rely on my witness statement, but I shall expound as I go along. So, as per usual, we would have noticed an ad for a tender by the NWRHA. So it was brought to my attention that the NWRHA had a tender out, and we would have seen this via notice in the newspaper. Upon that, we would have received a copy of the RFP. I would have reviewed it, and I would have attended the first pre-submission meeting, which was held on the 4th of December 2023. I would have attended and, of course, signed the register as per the requirements. A second pre-submission was held by the NWRHA. And again, this was on the 13th of December, and I again attended and signed on behalf of C.E.P. As per my job description inside C.E.P, I would have assisted in the preparation of the proposal in response to the RFP, and we would have prepared that RFP. I would have, of course, had prepared the documents and had the board of directors review and sign off before the proposal to be submitted on the 5th of January 2024. Upon that, after that, we would have been waiting, and then we would have found out, we would have received a notification of a decision to award from the NWRHA. That document, of course, is filed, stating that that they had evaluated the results, and C.E.P would have received a score of 81.5. Prudicon would have received a score of 77.8. We, of course, there was also an indication that the decision was made to award stage 1 to Prudicon. Based on that, I would have attended a debriefing session as part of the team with Mr. Mirage and Ms. Rodriguez. That would have been held in on the 5th of April. The minutes received on the 8th of April. And again, I would have been party to preparing the application to the OPR for review of that decision. So that's essentially the part that I would have played.
Okay, thank you, Mr. Ramluchan. Is Mr. Rondon, would you have any questions for Mr.? Oh, sorry, one moment. We would just tender and mark your witness statement as VR1. Yes, and go ahead, Mr. Rondon, if you had any questions.
Just on my initials are also VR, so not too sure.
Oh, but you don't have any witness statements, so.
Okay, so no problem.
So you're in the clear.
You have good initials, Mr. Rondon.
Excellent. Yes, I agree. So my only question, my question is, are you aware of the score criteria achieved or the marking points achieved by C.E.P Limited?
I am aware of the evaluation criteria as defined in the RFP, as well as the scoring of both Prudicon and C.E.P Limited in the letter of notification of decision to award.
And the score attained by C.E.P Limited, you're aware of what that score is?
81.5?
No, what is the score that C.E.P has achieved? The score.
81.
The final score.
Is it not 81.5?
Yes, sir. All right. And well, based on what we have submitted, well, I can't ask if you're in agreement with, because then that's deferred. So that's it for me. And probably, what is your understanding of most advantageous tender?
The most advantageous tender, I would, based on the fact that the RFP described a QCBS system, we would have the evaluation criteria would be defined in the RFP, but it would be the score would be comprised of both the technical score and the commercial score, both weighted and then summarized, and therefore 77.8 for Prudicon, 81.5 for C.E.P. And not only my understanding, but based on 1 second here. I'm just looking for the clause. In clause 28 of water contract of the instructions to proponents, it is clearly stated by the NWRHA that the most advantageous proposal is the proposal of the proponent that meets the qualification criteria and whose proposal has been determined to be substantially responsive. So that states that there's a technical and a financial part.
Yeah.
Also, it goes through the scoring criteria, and at the end of the scoring criteria, it shows that there's a tabulation of both the technical and financial, and then there is nothing after that. And then on top of that, your RFP states that no other evaluation criteria or methodology shall be permitted. So in my opinion, since you asked, it should have ended at the score of 81.5 for C.E.P, 77.8 for Prudicon, C.E.P attaining the highest score and therefore being the most advantageous proposal for the NWRHA.
No further question.
Sure. Just see if the panel members have any questions.
Mr. Luton.
Good day.
At the pre-submission meetings, there were two pre-submission meetings.
That's correct.
And at either of the pre-submission meeting was the scoring rubric revealed to you, by the NWRHA?
Ms. Lisa Joshua would have chaired that meeting, and the evaluation of the proposals, the criteria to be used was discussed because they would have gone through the various components of that RFP, and the evaluation criteria was discussed. And it's also defined in the minutes. I'm not sure which page, but it was discussed and it was reiterated in the minutes to the meeting.
So that is the evaluation criteria scoring.
That's correct.
That's what you're referring to.
Yes.
I'm now asking specifically about the scoring rubric, right, that accompanies that evaluation scoring.
What the scoring rubric being the weighting? I'm just trying to understand what you interpret as the scoring rubric. Are you speaking to the 20%, the 20 points that was supposed to be weighted to the commercial proposal?
Okay. In terms of a scoring rubric, basically, if we say that a particular criteria, right, carries a maximum score of 10,
correct,
right, then there's a rubric that says, okay, the candidate can be awarded a 5 or a 7 or a 3, as the case may be, right? So that specific rubric, was that discussed or revealed or shared with you at any of those pre-submission meetings?
So you're talking about the detailing of how each score could be, for example, the general background, how the score 10 would be assigned?
Yeah.
I don't think it didn't go into that level of detail. At the end of the day, it was the evaluation criteria was defined. It was defined as we would need to show our general background, experience, project schedule, and the different aspects, and it was made clear to us that what was put in the proposal is what was going to be scored, and so that's generally it, but no further breakdown or details of the individual items.
Thank you very much.
Okay, I had a question with regard to the site visits before responding to the RFP. Would there have been any sort of discussion as it pertains to whether this RFP was going to be in 2 lots or different stages that were connected or not connected to each other?
No.
Okay. And just one other question, in terms of the RFP and the RFP stating that it was an RFP without negotiations, I just wanted to understand, was it the reasonable expectation of CEP that negotiations would arise from this RFP? Sorry, without, is it dialogue or was it negotiation? Without negotiations, yes.
There was some discrepancy on that because the title page does state without negotiation, but within the RFP it does give does talk about negotiations in the case of a QCBS tender. So there seems to be some level of conflict there.
So the CEP's expectation that your understanding of whether it would have a negotiation would have arisen out of the evaluation, is it that it was a reasonable expectation despite the wording?
Sorry, repeat that last part. I missed that last part.
Oh, was it yes, was it a reasonable expectation that negotiations would have arisen in spite of the language that it was a RFP without negotiations?
At the end of the day, we should have expected. It is our expectation that we should have been negotiations should have had with us first before moving on to someone else.
Okay,
being the
sure.
highest. I mean, at the end of the day, we were the highest proponent.
Understood. These would be the questions for the panel. Now, Mr. Rondon, based on the questions that we have asked, if you have any further re-examination of Mr. Ramluchan, please go ahead. I see your hand was up.
Yes, ma'am. So, did CEP submit a stage 1 and a stage 2 of the proposal?
Yes.
Right. So, in submitting to a stage 1 and a stage 2 of the proposal, is the RFP in stages?
No. It's one project.
One project. But
in
there's
different phases.
Different phases. So there's a stage 1 and a stage 2, which clearly has a scope attached to stage 1 and stage 2, and clearly has a price point attached to stage 1 and stage 2. Yes?
But it's one project, one proposal.
So, yes, sir. So there's a stage 1 aspect of the proposal with a scope and a price point, and there's a stage 2 aspect of the proposal with a scope and a price point that CEP will have submitted to. Yes?
You rambled on. I need to get your question there. At the end of the
So
day,
no problem.
it's one
there is
proposal,
a stage 1,
one
yes,
price.
a proposal.
And your,
Yes, sir. Yes, sir.
May I complete? Because at the end of the day, it is one proposal, one price, one project.
Yes, sir. And there's a stage 1 with a scope and a price point. And there's a stage 2 with a scope and a price point that CEP will have submitted it to.
It's a request for proposals for one project, sir.
Okay. And there's a stage 1 that you, okay, let's rephrase it.
We are going wrong in circles, sir.
Did CEP submit a price point for stage 1 and stage 2?
As per the RFP requirements, sir.
Did CEP submit a price point for stage 1 and stage 2?
Yes, as per the RFP requirements, sir.
Okay. So therefore, there's a stage 1 and stage 2 aspect of the entire proposal.
Of a single project.
Yes, sir. That was clearly identified in the RFP document and that you submitted to. And stage 2 can only happen after stage 1 is completed. Yes?
I I don't know.
But can I award stage 2 and not award stage 1?
Why would you award in stages?
I'm just asking from your technical expertise. Madam Chair, is it that I'm allowed to ask persons in the room I'm asking you, sir. I don't know. I'm asking you from a state standpoint, from your technical knowledge and as the person who prepared this RFP document.
Yes.
Can I award you stage 2 without awarding stage 1?
No. Can
you start stage 2 without completing stage 1?
No.
Excellent. So therefore, we have a package that was submitted with a scope for package 1, stage 1, with a price point, and we also have a scope for stage 2 with a price point that was submitted. That CEP and Prudicon, and by extension, every other proponent who submitted a proposal submitted in that format. Yes? Yes? You're muted,
yes.
Sir? Yes. Okay, thank you. No more questions.
Thank you, Mr. Rondon. I believe, is there any, I believe this is the last witness for the applicant?
Yes.
There is, okay.
There were 2 witnesses, each Maharaj and myself.
Yes, so thank you so much, Mr. Ramlochan. Was there any?
Yeah.
Oh, okay. This was thank you for your attention today, and we would relieve you. I believe Mr. Maharaj can return to the seat.
Thank you all very much.
For the submissions.
So Mr. Maharaj, so that would have been your 2 witnesses. That would be the that, at least from our understanding, and just for you to confirm, that's the case for the applicant in support of its application.
Yes, Madam Chair, that's it for us in terms of the applicant. I would just want to ask, is there any other availability for us to say anything afterwards, or it's just the respondent and then we could counter the respondent, or what's happening next?
Well, the respondent will just give his opening statement. I understand he does not, he's indicated he doesn't have any witnesses, so he can just give his opening statement, just summarizing what the case for the respondent is. And we also we'll give an opportunity for closing submissions by both parties. If you're in a position now to give your, after that happens, if you're in a position to give your oral closing submissions, or I believe there's already directions for written submissions, so we can always forego the oral closing for the written submissions. But I'll leave that for the both parties, to give me an indication. I mean, we're here, so we're happy to hear your oral closing submissions.
And the oral closing submissions could be done now. I mean, not going to be submitted by the 3rd of May. Am I correct?
Let me just clarify if we would accept it. And
After.
yes. Yes, I was just confirming with regards to the oral closing, this would be supplemental to what you would be submitting in writing. So, I mean, the oral closing again would be a short summary of what would have transpired today and what evidence would have come out, and just to reaffirm your position. And we would expect that written submissions would be filed by the 3rd of May, I believe is the directions given. So
Okay,
at this
Madam Chair.
point, so just confirming again, for the applicant, this is the end of your case?
Yes, that's it for us.
Yes.
The only thing we will do, as I said, we would like to offer oral a closing statement, which we'll
Yes.
submit as a supplemental by the 3rd of May, as per the order of the OPR.
Okay, great. Thank you for that. So, Mr. Rondon, if you wanted to just give us a 5-minute summation of the respondent's case, so that we have you're able to put forward a clear understanding of your position.
But I'll try to maximize my 5 minutes.
Yes, please do.
So from the NWRHA standpoint, after we issued the public tender and went through all of the requirements and the submissions, we have an evaluation criteria that was identified, and we encountered an evaluation process. Coming out of that process, we had a top-ranked proponent, which was C.E.P. Limited, and we had another proponent, which was Prudicon. The NWRHA made a decision. Yes, we are deficit funded, as will be understood. And in the realm of procurement reform, the things that we used to do in the past, i.e. award a contract at a sum, not knowing where the funding is coming from, is no longer in this post-proclamation standpoint. We have releases from the ministry that only allowed us to safely award a contract in the amount of the where we actually have a deficit funding, because the releases from the ministry will cover the amount of $1,015,940, and the balance of the $500,000 is to be redirected from the recurrent expenditure to allow this project to occur. So the most advantageous tender for the Northwest Regional Health Authority with regards to the funding available is the proponent that has the lowest price submission at this point in time, which is Prudicon Limited. And Prudicon Limited represented the best value for the NWRHA. We must identify that both proponents have been deemed respondent to the RFP, and both proponents can do the work identified. And while the C.E.P. Limited would like to enter into negotiations or prefer to enter the negotiations, their bid submission difference to the stage one is $1,126,776.25. And if they are in a position to negotiate downwards, that is another opportunity or question or another remedy to this potential situation. They are also overall, from a costing standpoint, they are also the higher price point to the Prudicon overall for the stages. So it is the NWRHA's argument, or the NWRHA's defense, that we purely made a financial decision in going with the proponent that presented the lowest cost, notwithstanding the top rank. Now, the accounting officer has the ability to accept the evaluation report or reject the evaluation report or make changes to the evaluation report, again, based on sound grounds and information. And we are saying that that information is the availability of funding right now for the project. Yeah.
Is there anything else you wanted to add?
But on our end, with regards to the RFP document, we are stating that clause 23 for us is an option. It is not mandatory. And looking at the price point difference between the proponents, definitely a $1 million difference is pretty hard in these trying times to negotiate anywhere downwards to nullify same. Additionally, the stages of this project cannot occur they cannot occur simultaneously. They can only occur after one is completed. So based on the releases that we have and based on the time frame to do this project within this fiscal, we believe it was prudent to start the project by stage 1 and then make now an application for the stage 2 funding. And if we are successful with stage 2 funding, then we can proceed to tender for the stage 2 funding, or we can proceed now to negotiate with these 2 proponents, depending on the amount of funding that we have received.
Okay, would this be the end? I just want to.
Yes, ma'am, this will be the end.
Okay, thank you for summarizing the respondent's case. Just to go back to, I believe, a reply where you indicated you had no witnesses. So at this point, when there would be no witnesses for the applicant to cross-examine in that case. So what we can do now, we will just move swiftly to wrapping up.
Do I get to swear in also, ma'am?
Sorry.
Am I able to swear in also?
If you had a witness, okay. Yes,
well,
yes. The witnesses would swear in.
Okay, sorry about
yes, that. Yes, you are still representing you're the representative for the respondent. One moment, please.
Yes, ma'am.
All right. In terms of, so we now move into the oral closing submissions. Mr. Maharaj, you indicated that you would like to take the opportunity again. Parties can, if you will prefer not to give oral closing, in as much as there is going to be the written closing submissions, that is also fine as well. So there's no obligation, but certainly you're invited to do so. So we would start with the applicant in this regard, which would be a summary. Yes, and your oral closing is a summary. Yes.
Sorry, Madam Chair, we have listened to the submissions by the respondent. While I understand, and I mentioned at the debriefing meeting with the Northwest, we have been working with Northwest, and we understand their financial constraints. But the fact of the matter, and we will always remain, and we shall always rely on the fact that the RFP never indicated that the project or the intention of the Northwest Regional Health Authority to award the project in stages, as you may, and we will document, we will restate this in our formal written closing statement on or before the 3rd of May. As a commercial entity like anybody else in the world, when we do a proposal, we look at what is the requirement for the project. So when we sat looking at this, we looked at a project in its entirety, not in a stage basis. And if we are aware, as all the other proponents, that the intention of the Northwest was to award it in stages, we would have and may have, like everybody else, taken a different approach in presenting our case, because we know that, as Mr. Rondon, the respondent, clearly indicated, and we agreed to, you can't do stage 2 before stage 1. We understand that. But this RFP always spoke to a singular project comprising of 2 stages. And I would like to state, and we'll put it in our closing statement in written form, and I have no intentions to disagree. I'm just stating unequivocally that the ranking system, as shown in the letter dated the 26th of April, sent to us on the 27th, state clearly that based on the commercial submission for both stage 1 and 2 combined, coupled with the technical proposal, still ranked us at highest at 81.5. So to come now and say, and I'll put it more, that we use stage 1 only to rank. No, the ranking system was based on the combination of stages 1 and 2. 1 and 2. There's no demarcation of stage 1 and stage 2. It's a combined submission, which Mr. Ramlochan would have indicated in his written statement. And I say again, in the evaluation of award, which is evaluation results table, item 3 in the letter clearly states that we had 81.5% when taking into account the combined submissions of our commercial proposals for stages 1 and 2. And that is the basis of our position going forward. It was always stages 1 and 2. We and any other proponent formally were not aware of the fact of the intention of the Northwest to award it in stages. And that's basically the end of that's our closing remark, and that is the basis of our position, which we'll state in our closing summary by on or before the 3rd of May. I repeat, while I understand the problems financially, and I mean, I looked at the OPR and I understand there's some requirement that you can't go into procurement unless you have the funding. So that is really a moot point for me, but that's not for me to rely upon and rule upon. We are relying on the fact that it's a singular RFP that speaks to one project in 2 stages. And stage 1 and stage 2 has to be considered in combination and not in isolation, Madam Chair and other members of the panel. But as I said, let me close off now because we've been here for some time. We will document this in our in our closing remark. Because I will just say one more thing. You know, when we look at the evaluation criteria, so a Prudicon based on the assessment done by Northwest would have been better. But then when you look at stage 2, C.E.P was better. So is it the intention then, which obviously they can't answer now, that Northwest will then, after Prudicon finishes stage 1, will hire C.E.P to do stage 2? That's my closing point as well, which we'll have in the closing remarks, because our position was better for stage 2. I end, Madam Chair, and we'll submit our documents in closing on or before the 3rd of.
Okay, thank you, Mr. Maharaj. And Mr. Rondon, just to give your oral closing, a succinct oral closing, that's all.
Yes, when it comes to me, I find my time is short, Madam Chair. But anyway, let's go.
Both parties
Yeah,
are being
it will
very
be a
succinct, which we
disservice.
appreciate.
Okay, no problem, ma'am. Well, it'll be a disservice to the citizenry of Trinidad and Tobago, and as good stewards of public funds, for us to award a contract knowing that we have no money for sale. And that is our basis. There has been no dispute from the NWRHA with regards to the scoring attained by the both parties. And I think it is our position that we have made a financial decision. We have looked at what is the best value to the organization and by extension to the citizenry that we operate and work for. And according to our RFP, what is the most advantageous tender to the NWRHA, noting that both proponents were fully responsive to the RFP. We cannot operate business as usual pre-proclamation. We cannot make awards and hope that we will achieve some sort of miracle releases or finances. This is the realm that we're in now. And notwithstanding, we have an objective to achieve. It is the interest of the NWRHA and by extension all parties involved to be in a position to start a contract, knowing where the funding is coming from. Outside of that, one of the remedies being asked by the proponent is to reevaluate, and we will state that a reevaluation will net the same result with regards to the allocation of points and the ranking of the proponents. As it stands now, while the statement of it is an entire project. We do believe that stage 1 can start and be completed within this fiscal or straddling the fiscal time frame to allow us now to re-strategize and probably seek additional funding. We cannot determine what that exercise will look like in the future, but we do recognize that there is no way that we could want to award this contract in its entirety with the funding that we have received. And then the approach to award stage 1 is an attempt to salvage and start the delivery of our mandate. So we again throw ourselves at the court. We are definitely excited about the challenge proceeding. We're excited about the opportunity to get the direction from the OPR. We hold no malice towards the proponent. We do agree with the proponent holding us accountable. This is part and parcel of the new realm that we're in, and we're definitely part and parcel of the process. We will have some closing remarks. One of the learning lessons for me, though, as I have the platform, is that the system of financing definitely is not in tune with the requirements of the regulation. And that's something that possibly the OPR can now take, because we can't be in a position where we establish the amount and for the project, a nice internal estimate, and then when we look at the releases for that, it doesn't coincide with what we have estimated. That does not augur well for us moving forward any sort of process. So there has been an issue with regards to funds availability, funds confirmation, and releases that not only we have been struggling with, but other public bodies have been struggling. And how do you proceed? We have made a determination, again, when we reach to the award stage, to make a decision if we do have the funding, in the interests of trying to get the long tender process accomplished, and we can just probably hold. But definitely the system of financing that we're encountering right now does not line up with the requirements of the Act. And this is where we'll have these struggles on a regular basis. And that is our closing argument.
Okay, thanks. Thank you, Mr. Ronda. And you have nothing further. That's the end of your closing.
Yes, ma'am, that's the end.
Okay, you're welcome. Thank you. Just for the applicant, I just wanted to confirm with you, Mr. Maharaj, that you hadn't filed a Form 15 application for costs. I just wanted to confirm that. No? Okay.
No, we have not, but can we still do that?
I believe this would be the last. No, sir. Today? Yes, I believe today to file. Today
Before
would be.
midnight?
Just one moment. Let me just clarify. Yes, Mr. Maharaj, we're just looking back at your documentation when you filed, just to ascertain whether you had reserved that option. So in looking at it, you hadn't reserved the option to apply for costs. You wouldn't be able to do that now. So I'm sorry about that. But I know you.
Madam Chair, with all due respect, we knew that. We knew that. We were well aware that we were just finding out, for future reference. We'll just say yes, we reserve the right. Don't worry. Sorry about that.
Okay, that is fine. So this, of course, naturally would bring us to the end, as we've all, and you all are aware of, and who is not aware, it would be shared in terms of the directions for the written submissions to be filed. And just to give you all an indication, or just to remind you, in terms of the decision would be given on the 8th. Of course, we all recall that we're working within a statutory time frame. So we will give our decision. We'll review the evidence that was given today, the documentation that would have been shared with us as well. And we will provide our decision. You would get a notice, some indication from from the Secretariat in terms of that, and that would be shared with you. And then following our written reasons for the decision, which would be, one moment, let me just calculate, follow, but in any event, it will follow after the decision. The event, the written decision will follow, and we will let you know. We will definitely let you know. So if there's nothing further
So Madam
from,
Chair, I didn't get it clear. The written decision will come to us on the 8th of May?
no, we will let you know the reasons, the written, sorry, we will give you the decision on the 8th of May. We will give you the reasons for our decision thereafter, but certainly within the statutory time frame, in the event that you know,
Yeah.
it is required for something else.
Yeah, I think
Right.
the OPR says 14 days thereafter, which will be the 22nd of May.
Yes,
So-
great. So thank you.
So may I ask one question?
All right, one at a time in terms of our questions. Well, yeah, yes, the applicant, I think we still had you, Mr. Maharaj, you still had the floor, so
Yeah.
go ahead.
So having reviewed the act under the OPR, it doesn't preclude us if we do not accept the decision submitted on the 8th and the 22nd of May to pursue litigation if we choose to.
Well, I believe the legislation tells you what is the next step. So
Okay, good.
yes,
Fine.
yes,
That's
so you could follow through.
So
Okay.
jumping off of that question.
Yes,
Madam
Mr.
Chair.
Randa.
Madam Chair, so based on your decision, and if there's a potential appeal, what does with regards to the project, if you give us a decision, let's just say to proceed, and then the proponent launches an appeal, what happens to the project? Is it that we still continue to hold until the appeal, or do we proceed based on the decision of the OPR?
Well, in terms of if an appeal is made, that would be by that appellate body. So we can only tell you what will happen at our stage, and it is for the applicant and that the review board. They will make their own directions as to what happens in the interim while an appeal is being dealt with. But for our purpose, once we give you the decision and the reasons, we would have our role is ended in terms of at this level.
Okay, understood.
Yes. Any further questions, clarifications both parties needed before we leave? Everything is clear?
Clear as day, ma'am, clear as day.
Okay, and Mr. Maharaj, for you, are you clear as to how we're proceeding?
Yeah, Madam Chair, thank you so much. I think I can, the only reason why we said we would not file for costs is because we took this to be a learning exercise, which we decided to use our resources at no cost to the OPR and to the whole process. So we have already been approached by other persons who are lodging challenges to give them advice on how to proceed. So at least that's one thing. Maybe we'll make some money from that stage. Thank you so much.
I'm sure the respondent appreciates your generosity. So I would just like to thank both parties for engaging in the process and well, of course, I look forward to your written submissions for us to keeping our timelines and making, ensuring that the resources of the OPR are utilized efficiently and effectively. So with nothing else to be said, and I would essentially, tell you this is really the end of the hearing. This is the first challenge hearing that we are having. So yeah, so y'all are part of this process.
Are we the guinea pigs then?
So
History.
that's it. Yeah, yes.
Do we get a pin, I would like to get a pin, some kind of pin, commemorative pin, first challenge. That would be good.
Yes, indeed. So you both enjoy your day, and you look out for any
Yes, ma'am.
further communication from the OPR.
All right, no problem. Thanks so very much.
Okay, thank
Madam
you.
Chair, I noticed on the newspaper, a couple more challenges were posted.
Well, I guess
yeah.
you have some more clients.
No. What I'm saying, oh, I see what you mean. Yeah. Okay, yeah, no, that
Okay.
particular entity we can't get ourselves involved in. But so let's move on. Thank you so much.
All
It was
right,
really
no
indeed a
problem.
pleasure to meet with the members of the panel of the OPR, and it has been a very good, exciting, excitable learning experience for us. So thank you so much. And we look forward to, finishing this matter and closing it off formally by the 22nd. I think it might be whatever the document says. Thank you
Yes,
so much.
indeed. We will communicate with you.
Yeah, that's
Okay.
fine. Take
All
care.
right.
Have a good day,
Okay,
everyone.
sure.
Bye.
Bye-bye.
Bye.
Bye.